Hi class, today we're going to have to talk about abortion, which from a philosophical point of view is actually a fun thing, but of course in real life there's nothing fun about it at all. What's nice about it philosophically is we get to look at all of these various different ethical principles. Natural law in particular, natural rights, utilitarianism, deontology. We could even look at egoism. But for today, I want to really focus on the distinction between natural law and natural rights with respect to abortion. Roe v. Wade is based on natural rights. Virtually all conservative religions would say that abortion is bad based on natural law. So let's start with the natural law argument. From the natural law philosopher's perspective, it is unnatural to kill a fetus, just like it would be wrong to crush an acorn just for fun. For an acorn to fulfill its natural function, it should grow into an oak tree. For a fetus to fulfill its natural function, it should grow into a human being. For a mother to fulfill her natural function, she shouldn't kill the fetus, and so forth. From the perspective of natural rights is a very big difference. Natural rights, as you remember, says that we have 3 unalienable natural rights. That means we can never give them back, and they're life, liberty, and estates. Now the trick here is that with natural rights, these again are negative rights. That doesn't mean you get life, or get liberty, or even get stuff. Natural rights means no one can take your liberty, take your life, or take your stuff, and the job of the government from a natural rights point of view is protect your stuff. So, you never have to be a good Samaritan. If somebody's drowning and you want to save them, of course you can risk your life and do that, but you don't have to, because my liberty is mine, and that doesn't mean I have to risk my liberty to save somebody else's life. That's exactly the same idea with abortion. So, for example, there's a philosopher by the name of Judith Jarvis Thomson, and she gives an example, and I'm going to change it just a bit. Imagine you come into your house today after going to school, and there's a naked street person on the floor in your house, and he's plugged into a kidney machine of some sort in your house. Now, he's a disgusting man, and there's nothing about him that you find appealing, and you think, get out of my house. And he says, no, I'm not getting out of your house, because if you unplug me, I will die immediately. And you say, but it's my house. I didn't invite you in. He says, well, you didn't lock the door now, did you? Or I couldn't have gotten in so easily. And so then the question is, can you throw him out of your house? You didn't lock the door. I mean, you didn't put a condom over the front door, I guess. Can you throw him out of your house? The question is then, does his right to life trump your property right to your to your apartment? Can his right to life beat out your liberty? And the answer is generally thought to be no. I don't have to sacrifice my liberty for him to be able to stay alive in my house. I did not invite him in, and yet here he is. So I can evict him, and he dies. That's a shame. But that doesn't mean you have to keep him alive. So from the perspective of natural rights, it is legally justifiable to evict a fetus if, in fact, that fetus hasn't been around very long. And so what Roe v. Wade has done is it has actually taken 3 different sections. It talks about trimesters. In that first trimester, all states in the Union can evict the fetus, abort the fetus. Because at that point, there's no risk to the mother, strictly speaking, to evict that fetus, to abort that fetus. In the second trimester, there's a certain degree of risk. And so the state has more interest in protecting the rights of the fetus. Now notice, the fetus has rights. But just because the fetus has rights doesn't mean that the fetus's rights get to override your rights. And in the third trimester, it's even more difficult. And in the third trimester, we go back to natural law. Because Roe v. Wade would say it's really only under some very extraordinary circumstances that you can abort a fetus in that last trimester. And that's that idea we call principle of double effect. And that means you can only abort that fetus if your life is at stake. That means the goal is not to kill the fetus, the goal is to save your life. You would only get an injection because you want the benefit of the injection, not because you want the pain of the needle. So the principle of double effect is a natural law principle that says you can abort a fetus in that third trimester, but only if it's to protect your life. Now, of course, there's all kinds of things. So you have doctors and so forth that come into what level is the pain and what level is what's medically indicated and so forth. But the key is this. From a natural rights perspective, I have no obligation to protect the rights of the fetus. I can evict it. A utilitarian has yet a different point of view. From the utilitarian, the question is, well, if there's a lot of people who would really like to adopt babies and you're killing this fetus, well, that's a terrible thing, because there would be more pleasure in the world if we were to outlaw abortion and sort of organize mandatory adoption. So the utilitarians say, no, you can't abort the fetus because so many people would be happy if you were to have that fetus. On the other hand, if it turns out that there's overpopulation, then of course abort the fetus, because the generalized happiness would be having less babies being born. Notice the utilitarian does not care at all about the rights of the fetus. It doesn't care in the least. Utilitarianism is simply looking at the greatest net benefit. Finally, deontology. I don't know the answer to this one. The deontologist would say you should always make a decision based on the motives that you would think all people should have. So if you were to abort a fetus, then that would mean that you simultaneously would have said that were I in that position, my mother should have aborted me. Well, and so that would then mean that would I have had myself aborted were I in this situation? It seems to me that's the best that the deontologist can do. It's not typically something that deontologists look at. There's two other things to think about when we talk about this abortion debate. Number one is the ontological status of the fetus. It's a ridiculous term. It just means, what the heck is a fetus? And one of the things that we know is it's biologically human. It's one of us biology. It's genetically unique, but it may not be a person. And it certainly is not conscious, and it certainly has no interest. It doesn't want anything. So this word person is extremely important. Has the fetus reached a personhood status? If it's a person, it certainly has natural rights. If it is not a person, it has no rights. And this is something that Roe v. Wade is surprisingly silent on. They won't make that decision about the ontological status of the fetus. It doesn't really matter, though, because even if it is a person, you can still evict it. On the other hand, we do have a legal thing called adverse possession, which sort of comes into play. If I've been living in your house for 6 months and you've never thrown me out, I can say, look, I've been here long enough that you really can't throw me out. I have a kind of developed an easement. I now have access to your house. So one of the things that happens is if somebody's been on a property for a long time in flagrant disregard of what the landowner wants, they get to continue to be there. And if they do it long enough, they actually get to own that property. That's called adverse possession. But the question is, at some point, a reasonable, ordinary, prudent woman would have said, gee whiz, I guess I'm pregnant, and is determined to abort. Generally, I think that's why we have that first trimester. If you can't figure it out in the first trimester, then that fetus seems to have gotten some, squatter's rights to a certain degree. And if you haven't figured out by the third trimester, then it's very unlikely that this is the right thing to do, because now you should have known. It was unreasonable for you to keep this fetus alive. So there'd have to be some pretty extraordinary reasons to be able to evict the fetus in that third trimester, that last 3 months, unless your very life is at stake, and that's the principle of double effect. So generally, Roe v. Wade is based on natural rights. You have an unalienable natural right to your liberty, and that doesn't mean you have to give your liberty to anyone. If a street person walks into your house, even if you leave the front door unlocked, that person does not have rights to live in your house until they can leave. In other words, here I am, I'm a street person, I'm in your house, I only need to be here for 9 months, and when I leave, your floors will be stained and all, but after 9 months, I'm gone. Do you really need to let that street person live on the floor of your apartment for 9 months? A good Samaritan would say, geez, that's the right kind, good, sweet thing to do, but do you have to? If you choose to, that's your choice. That's you giving up your liberty of your own volition. But that person sleeping on your floor for 9 months naked has no way to take your rights from you. They can't compel you to give up your liberty. Okay, so that's the story. Abortion is not as simple as it's good or bad. It all depends on which of the ethical principles you use. Egoists are also funny. From their perspective, well, it all depends what's in my own long-term best interest. And you can figure that one out for yourself. For now, there it is. There's the basics of the abortion debate. Thank you very much. And that was not